Hello, my name is Robert Walker, accountant and insolvency practitioner. I intend to make a series on managing insolvency in troubled times, of which this is the first episode. Now, the reason for doing this is that we all confront together a looming recession, if not a depression. Now, what is going to happen during that time is that a very large number of companies and probably individuals are going to become insolvent and therefore fall into bankruptcy or some form of it. Now, what I'm going to do through this series is to outline why the best way of approaching this is Part 14 of the Companies Act, which is the description or the basis for the compromise regime, as I will refer to it from henceforth. Now, clearly, to be dealing with insolvency, you must know what insolvency is. I won't start there, though at the end of the session I'll briefly allude to it, as you'll see. The next session will be about what insolvency means. Now, suffice to say at this stage that insolvency is the prelude to bankruptcy. Insolvency is the state of being, bankruptcy is the legal consequence of it. So what I propose to do in this session is just to undertake a brief historical survey of bankruptcy across the ages, with a view to illustrating the different polarities that apply to it. So where I will begin is with the etymology of the word bankruptcy itself. Now, bankruptcy comes from, the word bankruptcy comes from Italian, and what it relates to is a broken bench. What it means, apparently, is that when a merchant became insolvent, unable to pay his or her debts, probably only him, they would ritually break his bench, the bench from which he traded, so he could no longer trade, hence the word bankruptcy. Now I'll move forward into the 19th century, and I will, to illustrate one polarity in the way that you can deal with bankrupts, from literature, and I refer to Charles Dickens. Now, what is poignant about Charles Dickens is that his father was a financial incompetent and ended up in debtor's prison. His father was the origin of the character in David Copperfield called Mr. Micawber. Now, Mr. Micawber is famous for saying this: annual income £20, annual expenditure £19, 19 shillings and sixpence, result happiness. Annual income £20, annual expenditure £20 and sixpence, result misery. Now, I think I would point out to begin with that Mr. Micawber's characterisation of solvency or otherwise is naive, but we'll get to that. What is perhaps more pertinent at this point is that where Micawber is saying what he's saying. He's in debtor's prison. Now, that was the way of dealing with people who were insolvent in the 19th century. We've always been a bit mystified as to how a person in prison was going to repay their debts, but it would seem to be that it was a form of slavery, in fact. But that's indicative, I think, of an attitude towards insolvent and bankruptcy. And that is that there was the touch of the morally reprehensible about it. Now, I've always been a bit surprised by that notion as well. We operate a capitalist system. Capitalist system is characterised by competition. In that competition there are winners and there are losers. Those losers will often become insolvent. It seems to me that if you think that state of affairs is morally reprehensible, then you might also see the capitalist system as being morally reprehensible. But I won't go any further than that. In any way, what I've illustrated is a creditor-friendly approach to bankruptcy. There were more extreme examples of creditor-friendly law. In some societies, people would be beheaded if they defaulted on their debts, but that is perhaps the height of creditor-friendly law. What I'm now going to do is I'm now going to explain the origins of the polar opposite, the debtor-friendly law. Now, to do so, we're going to go on an excursion into the history of the United States, and specifically to the US Constitution. The US Constitution discusses bankruptcy. Indeed, it reserves the right to the federal government to make bankruptcy law. And why is that? Well, there is little said about it in the Federalist Papers, those documents that underpin the philosophy underpinning the Constitution, but you can see it in something that James Madison did say. Now, James Madison was conscious of the limitations of the federal structure they were designing for the country of the United States. Now, what he was afraid of is that a defaulting debtor in one state would abscond with his or her assets to another state and be outside the jurisdiction of the first state, and the assets wouldn't be recovered. In other words, you can see that Madison's attitude to debtors was tinged with the notion of the morally reprehensible. But be that as it may, it caused the Constitution to reserve the right to the federal government. Now, what happened is in the following century, the 19th century, a series of attempts were made to try to construct a accepted bankruptcy law. And in the aftermath of each recession, and the 19th century was characterised by a series of booms and busts in the harmonic process that is the economy, which prevailed into the 20th century and now seems to have prevailed into the 21st century. It is a characteristic of the societies we live in. So in the aftermath of each one of these recessions, the US Congress would attempt to make a bankruptcy law. Now those things would become contentious once enacted, and then they would be repealed because they didn't suit everybody. And the reason they didn't suit everybody is that there was a kind of war taking place within the United States, and I will caricature this to a degree, between the Eastern bankers and the Western and Midwestern farmers. The Eastern bankers wanted a creditor-friendly approach to bankruptcy and insolvency, and the Western farmers wanted the opposite for obvious reasons. Now, what then happened is towards the end of the 19th century, the bankers commissioned a lawyer to write a draft law, and he did so in the late 1880s. Now, that bill languished, or that draft languished, for several years because soon after he drafted it there was another recession, even a depression in the early 1890s, so it didn't go anywhere. Then in the aftermath of that recession or depression, Congress had turned its mind again to bankruptcy law. And what happened is that they took this fellow's draft and they turned it on its head, and it became very debtor-friendly, which was quite remarkable. Now, that law, the National Bankruptcy Act of 1898, is the genesis to the current US bankruptcy code. It went through significant modification in 1938, which, as you'll see, is in the aftermath of yet another economic downturn, and then ended up in the 1970s and is now the bankruptcy code that prevails to this day. What is characteristic of the US approach to bankruptcy can be seen encapsulated in what is called Chapter 11. Now, Chapter 11 presupposes there must be a Chapter 1 to 10, indeed there are chapters after it, but Chapter 11 relates to very large corporations. And it is a very debtor-friendly law because what it entitles the corporation to do is to apply to the court to be protected from their creditors. In other words, a permanent stay is put on the creditors until the company is got back on its feet. And it exits Chapter 11, their rights are taken away from them. And so you can see that's a very debtor-friendly law. This is a very common process in the United States, and it is, as you can see that in General Motors, for example, has been through the process, United Airlines has been through the process, and I think you will find that we'll have another series of very large American companies will go through the same thing in the very near future. I'd have some sympathy with that approach to insolvency and bankruptcy. I think it's a bit too unfair on creditors. My view is that creditors should have a say, and I think that the New Zealand compromise regime strikes the perfect balance. In this case, the creditors have a lot more say, because the natural fact is a proposal put to creditors and they either accept it or reject it as a super majority, 75% basis, to be fair. Now, our regime comes from the 19th century in Britain, and it comes from a regime installed after the notion of limited liability was introduced in the Joint Stock Company Arrangement Act of 1870, and you can track the genesis of our compromise regime from those early days in the late 19th century. So there we have the two different views of how you deal with insolvency: creditor friendly, debtor friendly, and with it something that sits in the middle, which is our regime. Now, before I finish, I will also tell you that the National Bankruptcy Act is also radical in one other way. It introduced a completely new definition of insolvency, and I will deal with that in the next session. Please note that I have written a guide to compromise, and it is available from the sources underneath this video or in the credits as they roll past. Thank you very much for listening. Goodbye.